This meeting is being recorded.
Good morning and welcome to the Enterprise Ireland UK webinar, Construction in the UK and Ireland, a guide to legal issues and the UKCA mark. For those of you unfamiliar with Enterprise Ireland, we are the trade and innovation agency for the Irish government. Our teams in London and Manchester assist Irish companies in doing business in the UK and connect UK companies into innovative Irish solutions and partners. Today, we're going to examine some of the key legal issues in the construction sector across Ireland, Northern Ireland, and Great Britain. Firstly, our panel, Jamie Ritchie, Lisa Boyd, and Dominic Jones, who I'll pass you on to shortly, will discuss some of the many legal and regulatory issues currently facing contractors, employers, and suppliers in the industry across the three regions. Then I'll pass you on to Robin Byrne, the head of the UK office for the National Standards Authority of Ireland. Robin will discuss the UKCA mark, the new UK product marking that will replace the CE mark on the 1st of January 2023 in Great Britain. The UKCA mark will be required for construction products being placed in the market, and Robin will also discuss the process of how to certify your products with the UKCA marking. We'll then leave 10 minutes for Q&A at the end, so if you have any questions during the presentation, please send them through the Q&A tab at the bottom, and we'll do our best to answer as many as possible at the end. The session will also be recorded and distributed afterwards for you to watch or to share on if you'd like. So without further ado, I'll pass on to our panel to introduce themselves and to kick off the session. So on to you, I believe, Lisa.
Morning, everyone. My name's Lisa Boyd, and I'm a partner in Gateley Tweed in Northern Ireland and Gateley Legal in England, specialising in both construction and procurement law.
Good morning, everyone. I'm Dominic Jones. I'm a partner in the construction and engineering team at Blake Morgan, covering the full life cycle of complex building and infrastructure projects. And I'll be discussing current trends in the construction market from the GB perspective. On to Jamie.
Hi, everyone. My name's Jamie Ritchie, and I'm a partner with LK Shield Solicitors in Dublin. And I specialise in projects, construction and procurement law. Along with Lisa and Dominic, I've spoken at a number of EI events in recent times in which we followed the Brexit negotiations and provided commentary on the trade and cooperation agreement when it was agreed and its subsequent impact on UK and Irish construction trade. Today, I'm going to be focusing more on market shifts inside the last 12 months in a post-Brexit environment. So going straight into it, one of the main issues that has repeatedly come up in the last year has been in relation to fixed price contracts and structuring of responsibility under construction contracts. Main contractors in the Irish market and subcontractors for that matter are certainly paying much more attention to their legal obligations within their contracts. They're becoming much more attuned to identifying specific risks and aspects of their contracts which they have less control over, and they deal with those issues accordingly. In the private sector, typically as construction lawyers, we're brought in at an early stage to prepare documents which obviously go out to tender. And prior to the pandemic, there was always negotiation on contracts, but it was usually on specific provisions that you could plan ahead and know what was going to come up in terms of a negotiation. That said, the contracts themselves are becoming much more negotiated, and we're seeing that main contractors are willing to take on less risk, with at the same time them placing more risk on subcontractors and suppliers. This goes to the core of the standard of performance. Long gone are the days when you could get a fitness for purpose standard included within your contracts. Now, obviously, from a supply perspective, it's slightly different in the context of the statutory obligation to ensure that goods are fit for their normal purpose under the Supply of Services and Sale of Goods Act 1982. But from an overarching point of view, in a main contractor's building contract, it's pretty much universally accepted now that you're not going to get anything better from an employer point of view than reasonable skill and care. Obviously, there's been a number of high-profile issues that have arisen in the Irish market regarding materials in the last year. We've had the mica defects issue in particular, which has very much focused the minds of contractors to carefully review their definitions of deleterious materials and to ensure that they're appropriately protected downstream in regards to latent defects further down the line. In the design and build sphere, things have changed quite a significant amount. My own experience of negotiating these contracts with main contractors, employers alike, is that design and build contractors are increasingly in the Irish market seeing themselves more as construction managers and delegating risks. So this is being reflected in contracts whereby contractors are often attempting to, in negotiations, replace historically accepted absolute obligations in certain contexts with reasonable or best endeavours language for delivery. British standards are also being phased out of Irish construction contracts in favour of Irish standards. Obviously, prior to Brexit, it would have obviously been the case that you would have had British standards specified alongside Irish standards. But that hasn't changed the fact that a lot of materials still come from the UK, and that the fact is that many of the works requirements that I see in contracts do have British specifications in them. So there's a bit of a nuance to it, which we experience as construction lawyers when we're negotiating these contracts. Quite often, contractors are also seeking to carve out responsibility in respect of novated design team members. This includes caveats that contractors are routinely seeking to limit their risk for information provided by employers' design team members up to the novation, which is an interesting development. It's also becoming more commonplace for main contractors to lock down their lists of key subcontractors, that being subcontractors with material design responsibility. In the past, there would have been a lot more flexibility in regards to if you had individual packages that may further down the line be designated as having a design function, you could then add them to your key subcontractor list. But as projects are developing in Ireland at the moment, the industry is very acutely aware that they need to have their lists of key subcontractors locked down at an early stage, so that they have absolute clarity on the collateral warranties and product guarantees being delivered. Limitations and liability are constantly the subject of change as well, but it's very much insurance led, and I know Lisa's going to talk about that a little bit later on. We are finding that liquidated damages for late delivery are typically being carved out of liability caps and subject to separate caps. Third-party funders are also now often insisting that provisions are included in liability clauses whereby main contractors are under a positive duty to go after subcontractors, and monies recovered from subcontractors do not form part of overall caps in liability towards employers. Dominic, I think you're going to contrast that a little bit with the GB market, is that right?
Yeah, no, thanks, Jamie. It's really interesting to hear those experiences from the Irish market, and I'd echo your comments around sort of direction of travel and on a number of specific points like fitness for purpose. But we are seeing a slightly different approach to contracting in GB. I think it's still fair to say that design and build remains the most common procurement route. Perhaps what you've been describing gives a sense of a direction of travel, as I say. I mean, as a general comment, negotiations around risk allocation are certainly becoming much more involved. And there are examples of carving out or capping responsibility similar to what you've described. So liability in connection with a specific design package might be limited to the level of the PI insurance held by the relevant consultant, for instance, especially where the contractor has taken an ovation of the employer's design team. In some sectors, there's developing practice. So in the energy from waste sector, for instance, there's growing discussion around a move towards an engineer, procure and contract manage approach. Although I'd note that that's yet to find wide acceptance with funders. You mentioned, another point I was going to flag was around sort of vesting arrangements, and we're seeing vesting certificates used increasingly, in particular to support advance payments. so that orders can be placed in order to secure pricing, given the real concerns around cost volatility that we're going to come on to discuss a bit later on. In relation to the liability caps point that you mentioned, our experience does echo what you've described in terms of more granular negotiation around the scope of capped liability. And we are seeing those requests for liquidated damages to be included in overall liability caps. But so far, we're seeing employers resisting that approach pretty strongly on the basis that it creates a sort of perverse incentive that running up LADs would cut into the extent of potential liability for defects. And finally, one further thing we are starting to see here is a discussion around the question of limitation periods. Some employers are requesting that contractors and consultants extend limitation under contract to 15 years in respect of liability for breaches of building regulations or under the Defective Premises Act. And that's to reflect statutory changes to limitation periods that are anticipated in the Building Safety Act, which is due to become law later this year. So, Lisa, I think you were going to add a few comments from the NI point of view.
Yes, thanks, Dominic. Yeah, as Dominic says, I'm here to sort of give the perspective from the Northern Irish market. Dominic and Jamie have very skillfully covered off the main areas of concern regarding fixed pricing contracts and the allocation of risk. And the position in Northern Ireland is largely the same as what Dominic has explained in GB. It is interesting, though, that you're saying about the 15-year liability period being extended or extended to 15 years. We haven't seen that happen in Northern Ireland as of yet, but no doubt it will come across the water soon enough. Notably, we have seen recently an increase in a pushback from subcontractors, and as the market tightens, no doubt we'll see further interrogation of contractual provisions and structures from all parties within the contracting structure. So that leads us neatly into our next topic of the uncertainties of material prices, which I think, Dominic, you're going to kick us off on.
Yeah, I'll start with a bit of an introduction on that. And I suspect that most people in the audience are aware of the unprecedented volatility in materials pricing in the construction sector at the moment. The industry press is awash with analysis. Just to give a flavour, it was reported that steel prices rose 77.5% in 2021. Timber prices rose 80% in the first half of that year. And those inflationary trends are continuing into 2022, fueled by energy price hikes, the war in Ukraine, and associated sanctions on Russia and Belarus. In fact, last month, Building Magazine reported that material suppliers in some areas were holding quotes for only 24 hours due to fears over inflation concerns. And anecdotally, we've also seen on a recent project that practical completion was delayed because the global shortage in microchips meant that the M&E systems couldn't be commissioned. So against that backdrop, in July last year, the Construction Leadership Council wrote an open letter to the industry addressing the challenge of the availability and pricing of labour and materials, noting that this volatility is likely to be something we must live with for a while to come, with no specificity around exactly how long that might be. But the CLC made two recommendations. First, that parties should consider the use of the price inflation mechanisms that appear in standard form contracts, such as the fluctuations provisions in JCT contracts, the secondary option X1 in the NEC forms. And second, that parties should anticipate the risk of design changes arising from lack of product availability and should seek to manage those risks collaboratively, for instance, by allowing longer mobilization and lead-in periods and permitting upfront ordering to secure manufacture and delivery slots for critical materials. Now, for the last decade, 15 years or so, provisions of that type have been used very rarely, typically only in long-term infrastructure contracts or framework agreements. But in recent months, we've seen these issues arise in relation to almost every contract negotiation we've been involved in. Price inflation provisions in particular are becoming increasingly common. And those are mechanisms that typically allow for prices to be reviewed against a published index on a periodic basis. And the frequency of those periodic reviews is increasing as well. So you might have a review carried out quarterly or every 6 months. But in some cases, we're seeing it argued that inflation should be addressed monthly when considering each application for payment. And just briefly, finally, it's worth noting that labour costs are also continuing to escalate, with the long-standing skills shortages being exacerbated by post-Brexit immigration rules. And to give one example, the introduction of Planning Gateway 1, as it's referred to as part of the Hackett review of the building regulations, has highlighted a shortage of suitably qualified fire engineers who can prepare the necessary fire statements. And that lack of availability of fire consultants is leading to delays in securing planning permissions and bottlenecks at other stages of projects. So with that, by way of context, I think Lisa and Jamie, you're going to address a few specific contractual provisions that you've been seeing.
Yeah, so in Northern Ireland, obviously Brexit is still a hot topic. Post the vote in favour of Brexit clauses became the norm, I think, across all the jurisdictions, and such clauses span several pages and allocated the risk of price and time to the relevant parties of the contract. In my English practice, I've seen a trend of the removal of such specific clauses, with more emphasis on ensuring that change of law, price fluctuation clauses, and force majeure and the like are drafted broadly enough to cover any items that Brexit may continue to throw up. However, in Northern Ireland, the case still remains for Brexit clauses to remain at present due to the uncertainty of the Northern Ireland Protocol. The protocol sought to avoid a hard border on the island of Ireland, to ensure integrity of the EU single market for goods, and to facilitate unfettered access for NI goods to the GB market, as well as being included in any free trade agreements between the UK and third countries. However, in effect, it has produced somewhat of a border in the Irish Sea. The upcoming elections in May focus on this very issue, and some parties are threatening, some louder than others, not to enter power sharing if the protocol is not removed. What will happen remains to be seen, and for that reason, Brexit clauses are likely to remain in Northern Irish contracts for the foreseeable future. I would therefore recommend that anyone trading in Northern Ireland take specific advice on this point. On a similar thread, COVID clauses that were once prominent in both English and Northern Irish contracts are starting to make a retreat. Emphasis again has now been placed on the drafting of clauses to give room to deal with COVID issues rather than standalone provisions. Is that the position that you're saying, Jamie, in Ireland?
Yeah, it's not too dissimilar in terms of Brexit clauses. I suppose that they're there, but the content and form of them has changed a little bit. Whereas previously it was very much a focus on, no increase to the contract sum, but you might get a little bit of time out of it. That an extension of time might be granted, and that would be pre-agreed in relation to individual incidences where materials weren't available, and you might agree 4 weeks or 6 weeks or something along those lines, just to practically reflect the issues that were going on with sort of importation with goods. What we're finding now is they've become a little bit more refined. You're not getting time, but there may be a mechanism in there for a contractor to propose an alternative material, whereby they can make this proposal, and it has to be of an equal or better standard and subject to the employer's approval. So that's what we're seeing on Brexit. On COVID, public works contract during the lockdown phase has sort of dealt with it by way of an ex gratia payment, which included a calculation for how contractors would be paid during the shutdown phases. Private sector was a wee bit it was a little bit more complex. The approaches varied a little bit. Some employers were quite pragmatic and agreed amendment agreements with their contractors to give them a bit of money and carve out the COVID risk. By and large, where it's landed today is that certainly in the private sector contracts, the larger private sector contracts, there's either an amount that's agreed, which you have to be able to demonstrate as a contractor you've had loss in the event of a site shutdown, or it's just not permitted at all and you only just get time. But the critical point is it has to be as a result of a site shutdown rather than just a local outbreak within the site itself. We're also seeing, interestingly enough, in the last month or so, Ukraine clauses coming into contracts. So that there's a lot of materials and goods that come out of the Ukraine, and that's an issue which has reflected itself in contracts and how the risks are being addressed as part of that. And also price inflationary measures. I know that's been mentioned by Dominic. There is, prior to COVID, nobody obviously could have seen that coming. And after a short period of time, everyone was looking at their changes of law provisions in around March and April 2020, trying to figure out how the contract responds in the event of the emergency legislation. Well, it's not possible to predict at the moment whether the European Union might not put in a statutory inflation measure for individual materials and pricing across the board for say, for example, steel or something like that, price controls. That could have an impact in future. So there are risks out there, and for that reason, quite often it's maybe, interestingly, a little bit of a distinguishing factor in Irish construction contracts. A lot of these issues are actually housed under the changes of law provisions in Irish construction contracts, even if they're not necessarily directly related to changes in law, but they sort of try and specify out individual incidences where legislative enactments may come into play. So that actually neatly ties in with the next section, which we're going to talk about, which is changes in law. So I think Dominic, you were going to kick off with that.
Yeah, exactly. Thanks, Jamie. That's another area where we're seeing increased attention is that issue of how changes in law are to be addressed in contracts. And I'd say from my perspective, the provisions themselves remain fairly standard. So where there is a change in law clause included in a contract, such as option X2 in an NEC form, that provision would typically allow for relief for the impacts of a change in law that arises after the contract date or after another specified base date linked to when pricing was fixed. And those provisions are often subject to a proviso that the change in law was not anticipated or shouldn't have been anticipated at that base date. And we discussed at some length last year how those provisions were tested by the government's response to COVID, at least in England, because of the extensive use of guidance in setting rules around social distancing and self-isolating. And in essence, the fact that requirements were based in guidance as opposed to in any hard law statutory provision raised the question of whether the introduction of that guidance could amount in itself to a change in law within the meaning of relevant contractual provisions. The traditional position on that was that only changes in hard law would qualify as changes in law. But we have seen it argued that because failure to comply with guidance could have led to enforcement action, that guidance had the effect of law and should therefore be treated as a change in law, entitling the contractor to relief. Now, as a generality, I think similar to what Jamie was saying, I think it's fair to say that on most projects, this issue was kind of sidestepped because the parties were able to reach a commercial agreement, typically on the basis that the contractor would be allowed time but not money for COVID-related disruptions or some similar arrangement. But in cases where a deal of that type was not reached, we are now seeing disputes bubbling to the surface at the final account stage And some of those do involve relatively large sums of money and some novel questions of law. So it wouldn't surprise me if we do see a test case being brought to court in that area. And another live issue I was going to mention is around the impact of changes in national insurance contributions. So as of the 6th of April this year, the Health and Social Care Act 2021 has introduced a 1.25% increase in national insurance contributions, which is to be intended to fund the NHS and health and social care in the UK. And depending on the wording of the specific clause and the applicable base date for the relevant contract, it seems likely that in principle, that change in the requirement to make NI contributions will amount to a change in law. That raises then a couple of points of detail. So first, a contractor's claim arising from that change in law would be for costs arising from the change. So sort of squarely falls into that addresses the additional contributions that a contractor would be obliged to make in respect of its employees. But that does mean that the employees' contributions themselves would not directly be caught unless the contractor elected to uplift salaries or payments to compensate for the increased contribution from the employee's side. And second, the contractor will need to show that any costs being claimed relate to the contract works themselves. So if an employee is allocated only to a project on a part-time basis, then the cost recovery would relate only to on a pro rata basis to the element of time allocated to that scheme. Lisa, I think you were going to touch on the new rules around red diesel.
Yeah, thanks, Dominic. Yeah, in relation to the changes of law, I had a recent interesting example, which was in relation to the red diesel. Following the announcement in 2020, the exemption for the use of red diesel in many industries ceased earlier this month. I had one client alone who presented me with 20 plus bespoke contracts and asked me where the risk for the red diesel change in law lay. So unlike what you were saying, Dominic, it wasn't a standard form. So there was 20 different provisions to look through to see where the risk and responsibility lay. The drafting of the change of law clauses across these contracts, while similar in themes, varied. Rather than having one route of action, the client had to approach the employer in each contract in a different way to discuss the implications of the change in law in respect of the red diesel. And the outcomes under the contract varied between the contractor being fully liable to the employer being fully liable. Deciding factors, as you'd alluded to earlier, Dominic, on the most part lay within whether or not the change of law was known at the time that the contract was entered, and or whether or not the change of law in respect of diesel was caught within the definition of a change of law that fell to the responsibility of the employer or the contractor. The market and regulations are changing more rapidly than any other periods that I can recollect, and it highlights the importance not only of considering the drafting of this type of clause, but also considering what consultation papers and draft bills are in publication at the time of signing any contract, as the parties may find them bound by foreseeable future legislation which isn't currently in force. And somewhat of a tenuous link, I'm going to segue into, after speaking of consultations and draft bills, raising that the Cabinet Office has published its response in respect of the consultation on the future of public procurement in the UK. We don't have a date yet, but it's expected that the draft bill will be published later this year and that the new regulations will be coming into force in 2023. The Cabinet Office has confirmed that they will give 6 months notice of any go live date in order to support the implementation of the new regime. The bill will see the UK deviate from the EU regime, albeit bound to some extent by other trade agreements, and in that respect some things will remain aligned. With proposals as to central debarment lists and supplier registration systems, there will be a lot of work that needs to be undertaken by all participants in the public procurement sphere to be ready for the change in regime. The Cabinet Office has regular updates, and if you go onto their website, you can subscribe so that you don't miss any news in this area. They've also indicated that as they get closer to the launch dates, that they will schedule information sessions. And so I would recommend that anyone involved in UK public procurement registers so that you don't miss anything. Jamie, I think you wanted to touch on an interesting point that's arisen in Ireland in respect of the status of UK tenderers post-Brexit.
Yeah, I mean, from an Irish point of view, there was a lot of concern prior to the Brexit arrangements being finalised that it was going to create a difficult situation for UK tenderers within the Irish market and vice versa. I think it's fair to say the situation has been largely preserved. The UK acceded to the GPA, and they can't treat Irish public bodies can't treat individual contractors any less favourably than the treatment afforded to economic operators within the Irish market. One of the big points is that there are going to be there are currently a lot of public projects within Ireland, and we're seeing an increasing amount of UK tenderers for construction works in Ireland, particularly Northern Irish tenderers. The only thing I would say is that there's historically been less of a willingness to challenge procurement decisions in Ireland, but we're starting to see a slight shift in that. Interestingly enough, quite a few UK tenderers are kicking the tires and more inclined to question the basis for decisions, maybe not through a formal challenge, but certainly looking at it from a very preliminary point of view in engaging in discussions after procurement decisions have been made. But other than that, yeah, the situation is largely preserved. I think you were going to say something about force majeure as well, Lisa.
Still on mute, haven't learned after 2 years. I just wanted to touch briefly on force majeure clauses, which ties into what we were talking about earlier in respect of the reduction of Brexit and COVID clauses. Force majeure clauses deal with unforeseen circumstances beyond the parties' control which impede the progress of a contract. As an example, force majeure clauses were relied upon heavily at the start of the pandemic. After all, it was unforeseen, outside the control of the parties, and prevented contracts from being progressed. However, several months into the pandemic, we adjusted to the new norm of pandemic life, and courts were less willing to hold that COVID circumstances were outside the control of the parties and or unforeseen. That was when we first saw the explosion of the COVID clause. Fast forward 2 years, and whilst COVID clauses are being scaled back, it's unlikely that COVID would be seen to be a force majeure event, given the new strains and lockdowns are reasonably foreseeable at this stage. Courts will therefore expect that parties to a contract will have considered any COVID-related impacts, or indeed other items such as Brexit, before entering into contracts. This reinforces the need to ensure that your contract-specific concerns in relation to COVID and Brexit are addressed accordingly. And now we've talked about all the issues that may spring up, and we're going to spend a little bit of time just exploring dispute resolution across the various jurisdictions. So I think, Jamie, you're going to kick off on that one.
Yeah, I'm just a little conscious of time, so I'm going to do a bit of a whistle-stop tour of adjudication. The Construction Contracts Act came into effect in July 2016 in Ireland. It regulates payment within the construction industry, and it provides for a statutory right to adjudication, which is a fast-tracked construction dispute resolution mechanism. It's existed in the UK for 20 odd years, or over 20 years, and in Northern Ireland, but it's fairly new to the Irish market. Conciliation was always the name of the game in terms of construction dispute resolution. There was a degree of reticence about its enforceability, concerns within the market about whether it would actually work from a practical point of view. there was discussions around cultural differences and whether the Irish market was more inclined to sit down and negotiate rather than hitting the nuclear button and going to adjudication. But in the last year, a lot of that ambiguity has been put to bed. We had our first, the Irish courts had their first enforcement of an adjudicator's decision with Gravity Construction and Total Highway Maintenance last year. Very much a very black and white decision, effectively whereby the court granted an unless order, which required payment within 7 days, which was very significant because it showed that the court supported the adjudication process in Ireland. We also had Pure Fit Out and Acon Construction. Effectively, again, it was the same situation where the adjudicator's decision was enforced. There were a number of challenges that the party responding failed to issue a pay less notice, which is a requirement under the construction legislation if you're going to withhold any amount of money. And the adjudicator awarded in favour of the referring party. As I say, there's a number of defences on the ground of the full value of the claim not being properly considered and procedural fairness, but the reality was that the courts came down pretty hard in saying that adjudication will be of limited practical benefit if the outcome of the process, i.e. the adjudicator's decision, can't be enforced properly. So that was very, very persuasive. There were other decisions in 2021, such as O'Donovan and Byrne and Principal Contractors, Beneven Contractors, and more recently, John Paul Construction and Tipperary Cooperative. So the very interesting development in a short space of time. I know that the numbers of adjudications during lockdown, I think they sort of plateaued or maybe even slightly went down a little bit during the COVID lockdowns from a peak just before the pandemic. But I could see the number of adjudications significantly increasing when the annual report is released later this year. So that's a very interesting development for the Irish market, and something which both UK and Irish contractors doing business in Ireland should be aware of. Dominic, I don't know what's the position currently in the UK in GB?
Well, as you say, I'll conscious of time, so we'll sort of skim through it fairly quickly. But as you absolutely rightly mentioned, adjudication has been a feature of the landscape here for 24 years this month. So it's very well established. And to the extent that a Court of Appeal judge commented in a decision recently that for many construction disputes, adjudication is the only game in town. So it's intended exactly as you've described, as an interim solution. But because of the costs involved in going to litigation, adjudication can be treated as the final forum for dispute resolution. And certainly the case here is that the courts will enforce an adjudicator's decision through a summary process, save in very limited circumstances. And it's then for the parties to relitigate the dispute once payment of the adjudicator's award has been made, or satisfaction of the adjudicator's award. I was going to mention also one area very briefly, which the courts have considered recently, which is the interface between the adjudication regime on one hand and the insolvency rules on the other, because there's a bit of a tension between those. You've got adjudication, which is about this swift interim binding resolution to release cash flow, and the insolvency regime, which introduces a mandatory set-off that has to take account of all claims and cross-claims when a company enters liquidation. And key cases here are Supreme Court's decision in Bresco and Lonsdale and the Court of Appeal's judgment November last year in John Doyle and Erith. And in short, the current position there is that an insolvent party can commence an adjudication, but crucially, summary enforcement of an adjudicator's decision will only be available in very limited circumstances, where that award addresses all cross-claims and where clear, evidenced and unequivocal security is provided by the insolvent company. So a bit of useful clarity on that interplay. Lisa, over to you for anything on the NI position.
Yeah, the situation in NI is largely the same as it is in GB. I think we were a few months, if not a year, behind the GB in introducing adjudication. So it's well established here, and we're certainly not as hesitant as the Irish market in issuing adjudications here. So it's definitely the norm in resolving construction disputes. Just to swiftly move on, because I see time is marching on, I was going to touch on briefly the position of insurances, which is the penultimate point I think that we're going to touch on today across the three of us. So the insurance market, I'm sure everybody's finding, is tough at present, and it doesn't look set to soften in the near future. Insurances are being sought for new projects at levels in some cases that can just not be achieved through no fault of the company required to obtain those insurances, either because the premium is just not economically viable or because the requisite coverage is not being offered on the market. The parties therefore need to strike a balance between what is practicable and what provides security for the project. I've seen a range of innovative solutions to such problems, from lower insurance for the life of the project, ranging right through to bespoke insurance arrangements, allowing for increased insurance coverage as and when the market softens. Of course, this needs to be backed up in any case by a broker's letter to confirm that the insurances are not available. The problem is equally tangible for live or completed projects where insurance needs to be maintained for a certain period of time. Contractors need to be proactive in such circumstances and seek concessions from the employer and the contractual insurances required, even if it's just for one insurance period, so that they're not in breach of contract. This can then be revisited at the next renewal date. As Dominic and Jamie touched on earlier, insurances then tie into the liability caps that'll apply in contracts as well. So they go hand in hand. And it's important that once you've reviewed your insurance provisions, that the liability provisions are also looked at. Dominic, I think you were going to touch on this as well.
I was on mute, someone had to do it. Yeah, just really to echo that general point that it's been a real turbulent few years for the PI insurance markets. And certainly we don't see signs of things softening, but maybe stabilizing a little bit. So I think for a long time, each and every cover was very hard to come by, and aggregate limits of indemnity, sometimes with a fixed number of reinstatements, were very common. Levels of deductible increased, and as the premiums, we saw exclusions of liability for fire-related risks, for instance. But there's just a sense that with recent renewals, cover on an each and every claim basis may be becoming a bit more available, but always subject to specific exclusions or sublimits of indemnity. So, for instance, I've seen some insurers saying that cover for cladding or fire-related risks will be limited to a low aggregate figure for any claim relating to the period prior to the current insurance term, but a high limit on a forward-looking basis. I think we're short of time, so I'll pass on to Jamie for anything on Republic of Ireland.
Yeah, no, I in the interest of time, I'm just going to say that what you're saying very much reflects what we're seeing in the Irish market. Everything is tightening up, and you need to involve a broker at an early stage. I think it's helpful to get the parties brokers in the rooms actually, or on Teams call to sort out specific issues. I think we're going to move on shortly to Robin's part of the talk, but there's just to mention on the ROI side. I mean, CE marking in the UKCA, the principal legislation is the European Union Construction Products Regulation, which transposes the EU directive. So I know that Robin's going to speak in this in much more detail than I can. I don't know if, Lisa, you have anything that you wanted to mention just before we pass over to Robin.
Yeah, just very briefly, the guidance for placing manufactured goods on the market in NI is different depending on whether you're placing them on the EU or the GB market. Goods with the CE market can be placed on the market in NI and the EU, but there's also the UK NI mark, which is to be used alongside the CE marking if the goods are being placed on the market in NI and a UK body has carried out the mandatory conformity assessment. You can't use the UK NI mark for goods placed on the EU market. So before I get myself in too deep on the various markings, I'm going to pass back to Luke, who can introduce Robin, who's the expert in this area.
Lovely. Thank you for that, Lisa, Jamie, and Dominic. Very insightful discussion and some great information there for all of our audience members. So now, on to the second part of our webinar. I'll pass you on to Robin, who is going to discuss the UK CA mark and some of the upcoming changes and how to get ready. Just to note, if anyone needs to jump off in the interest of time, the session is being recorded. So feel free to drop me an email at luke.newcomb@enterprise-ireland.com and I can send you on the rest of the recording afterwards. But yeah, I suppose we're ready whenever you are, Robin.
Thanks, Luke, and I hope you can see my screen sharing. So my name's Robin Byrne. I'm the head of Nsa Certification UK Limited, and what I'm going to discuss with you today, give you a little bit of background in our organisation, and then get stuck into UK CA marking. So what is it? What's the process? And then I have a list of frequently asked questions that myself and my team deal with on an almost daily basis at this stage. So Nsa Certification, we were set up on 15th of July 2021. We are a subsidiary of NSAI, who are based in Ireland, and another sister company, NSAI Inc., in Nashua in the USA. And we were set up specifically because of Brexit to be able to offer UK CA marking to our clients in addition to CE marking. We have an office based in London. It's in Uxbridge, I think, very close proximity to Heathrow, which is great for meetings. But at the moment, you know, there's only a team of two. There's myself and my admin staff, Siobhan. So we're working remotely at the moment, and we do have a recruitment process in place for medical devices. Right now, we're dealing specifically with construction products and with non-automatic weighing instruments and measuring instruments. But we also have an application in with UCAS and the MHRA for medical devices as well. So it is going to get quite busy there. In terms of our accreditation, we are an EU notified body, have been since July 2013 under the Construction Products Regulation, the EU, and we have applied for UKCA accreditation by UCAS, successfully completed our remote desktop assessment in February, and we're just awaiting our final assessment date. So the current scope that we have at the moment is basically the same as we have under the CPR. So precast concrete products, cements, gypsum products, structural steel to EN 1090, a large range of aggregates, timber products such as wood-based panels and structural timber, mortars and bituminous mixtures, and concrete blocks. So it's quite a narrow scope that we have, and it was based on, let's say, the majority of manufacturers who we were dealing with in Ireland. There is a possibility to extend that scope, obviously, over time, once we get the approved body status with UCAS. So obviously, if there are products there, or the products on that list that you need UKCA or CE marking for, get in touch with me and we can look at extending our scope. So UKCA marking, what is it? Well, you have the logo there. It's basically the new product marking, which is used for goods being placed on the market in England, Wales, and Scotland. Now, as Lisa mentioned, lovely little segue into my presentation about UK NI marking. Northern Ireland is a special case and is dealt with differently for the product marking, which I'll get into in just a sec. It's mandatory from the 1st of January 2023. Now, I believe it was actually mandatory from 1st of January 2021, but you know, they have this kind of hybrid approach until the 1st of January 2023, when they're able to allow UKCA or CE marking. But from the 1st of January next year, it'll only be UKCA marking on products that are used in the UK. Now, the UK NI marking is different, as it covers products being placed in the Northern Ireland market, which, as Lisa said, have undergone third-party conformity assessment by a UK-based body. So that's if you've an approved body, who's currently a notified body, that are based in the UK, and they've done the, let's say, the System 1 Plus or System 1 or System 2 Plus factory production control, or even System 3 for laboratory testing. They've done the work there and CE marked the product. In that case, the product will, if it wants to be used in Northern Ireland, coming from a UK body, there'll have to be the UK NI marking beside the CE. Now, I say beside because market surveillance have notified me that they have come across cases where when they've looked at a product label, it has CE on one side, and then when they turn the label over, it has UK NI on the other. Now, I'm all for reduce, reuse, recycle, but that's against the requirements of the regulation. It must have the CE mark and UK NI mark beside each other, clearly visible on either the product itself or the product packaging in some areas. Process, thankfully, it's very similar to CE marking under the Construction Products Regulation. There is a UK version of the Construction Products Regulation in existence, and I believe it's very similar to a cut and paste. So first step, exactly with CE, check and see if your product requires it. So is there a BSEN that covers your product type? Check that standard for the product, and also check the route for conformity assessment. Now, at the moment, those BSENs, they should have an Annex ZA, which gives the requirements for CE mark, and so you'll have your table of essential requirements. You'll also have your what the attestation of verification of constancy of performance is, which is basically whether you need a notified body or not, and what are the various roles and responsibilities. Once you've gone through that conformity assessment, if it's self-declaration or you need a notified body, you'll then draw up your UK declaration of conformity, which is similar but worded differently than a declaration of performance under CE marking. And finally, you'll affix your UKCA marking. Obviously, if you're selling into Northern Ireland and you're using the UK body, you'll have to affix your UK NI with the CE marking beside it. So for now, the process is literally a mirror of what we were doing with CE marking. It's only the label has changed, and for notified bodies, we have to become approved bodies under with UCAS under UKCA. So the process for NSAI is very simple. Request an application form. We call it an RFQ, request for quotation, from my colleague Siobhan Agar. Her email address is on screen. We also request you include your current CE certificate and the most recent audit report. The reason we do that is that what we try and do is look at it almost like a transfer of notification or a transfer of certification. So we try and streamline it as much as possible. The audits, they follow the same format as CE marking. Because again, the attestation levels are the same. So our plan within NSAI is that we do both audits on the same day as the same audit where required. It is a requirement of the Construction Products Regulation and probably the UK one that notified bodies and approval bodies should avoid placing undue financial constraints on their client base. So that's why we're trying to merge the two as much as we can. So some of the frequently asked questions, and I am aware of time, and I know there will be some Q&A coming through. Does UKCA follow the same format as CE? Yes, it does. And the best information we have is that it will for the foreseeable future. It's the same with people have asked us, you know, does it still use EN standards? Yes, but you must look at the BS EN just in case there's a national annex there. As you can imagine, it would be a very long, laborious process to drop the EN standards in the UK and to try and adopt new BS standards. So that process may go on in the background, but certainly for the next couple of years, it's still the BSENs, exactly as we were with CE marking. Where can I get my product tested? Under CE marking, I'd send you to the European Commission NANDO database, which has the list of all the notified bodies. For UKCA, it's the UK Department of Business, Energy and Industrial Strategy. and they are the holders or the keepers of the database of approval bodies. So go onto their website and they have it broken down into product types. You can click construction products, toy safety, whatever you want, medical devices, and you'll find them there. What about products I've supplied to the UK before the 1st of January of next year? So again, quite similar with CE. If you have supplied product before the deadline date and it has CE marking, not UKCA, that's perfectly fine to be used and to be stored and stocked in the UK market once it was supplied before the 1st of January. If you supply a product, ship a product after the 1st of January, it's UKCA or it's rejected. So if you're supplying product to the UK, you can continue to do so with CE marking right up until the 1st of January. And that product can be in storage for its shelf life and can be used once they're able to prove that this was supplied to them before the 1st of January. The final FAQ I have, do I need the CE mark as well as UK and I mark for Northern Ireland? We get this question asked a lot, which is why I've kind of repeated myself with it. Northern Ireland is a special case. So yes, you need the CE mark as well as UK and I. So if you're selling products to England, Scotland, or Wales, it's UKCA mark only. If you're selling products to Ireland or the rest of the EU, it's CE marking only. If you're selling products to Northern Ireland, it's CE plus UK and I, both marks labeled clearly and beside each other, so everybody can see that you have both certifications. So that's, again, very quick. I apologize for time as well. Thanks very much for your time and attention. For more information, feel free to contact myself or Luke or my colleagues in Enterprise Ireland, and we'd be more than happy to deal with any of your questions. So I'll hand back to Luke now and the rest of the guys, and we can have our Q&A session.
Perfect. I suppose we turn on our cameras there and we'll go to the Q&A. Lovely. The first one's actually come through for yourself, Robin. And you mentioned obviously the standards for the UKCA and the CE marking and how they're quite similar at the moment. And the first question is just asking, do you see the standards of the UKCA mark sort of diverging from the CE mark in the future as Brexit kind of settles in?
Yes, but quite a distance into the future. I've discussed this with other notified bodies, in the UK. I'm chair of the Irish Notified Bodies Network as well for my sins, and the information that we're getting from BSI is constant and consistent across the board, which is there aren't any plans at the moment. The deal was done to have the two the same. So yes, I'd say for the next number of years, it will be just the BSCNs, and that's to make it easy for all markets, so we don't have bottlenecks occurring.
Okay, perfect. And the next one is just looking at an importer address. So does the UKCA mark require a UK importer address to be provided?
It depends on, let's say it's written in the regulation, but if you are importing a product and then distributing it, then yes, your details should be on the product label under your roles and responsibilities. As well as that, it's important that any handling or safety information is available. If it's going to be UKCA marked and you're a UK importer, it must be available in English if you're importing from a foreign country. Okay. So again, I always recommend people get your hands on copies of the UK regulation and the EU construction products regulation, and do a compare and contrast yourself. Some of them are written in a little bit of legalese, but I always think that there's annexes at the back which are absolutely terrific in how to draw up a declaration of performance or declaration of conformity. So definitely get your hands on a copy of the regulation and make sure you're complying.
Brilliant. Thanks, Robin. And now one for the panel at the beginning, a sort of general question. And what would you see as the sort of key, I suppose, legal or regulatory issue in each of your market in the coming years for kind of construction companies to keep on top of? Maybe it's something you touched on earlier, or
who wants to go first?
I'll kick off with a very quick one, which is the Building Safety Act, which is sort of touted as the biggest change in building safety regulation for the last 20 years, and is going to have impacts on various initially sort of high-rise buildings, but it's likely to trickle down into safety across the piece. So that's one thing to look out for.
My take home would be on for anyone in the public sector, it's the new procurement regs coming home are coming into force. That's going to really shake up how procurement is conducted across the UK. So just to get signed up for those updates and keep an eye out for any seminars and things like that that are going to give some good advice on how to navigate your way through the new regime.
From an Irish perspective, I would say that with the shrinking margins and the price increases in materials and the uncertainty within the industry, I really think that adjudication is going to be something which a lot of Irish contractors are going to be getting themselves involved in over the next year. And I would say that it's still heavily underutilized within the marketplace when compared to the UK, and that will have a major impact on the market at large.
Okay, brilliant. I think that's all the questions that have come through today. So if there are any more, as I mentioned, feel free to get in touch and we'll do our best to answer them. So I'd just like to thank our panel today. So Lisa, Jamie, Dominic and Robin, thank you very much for taking your time. Very insightful discussion and very informative for all of our audience members. As I mentioned, the session is being recorded, so I'll make sure to send that on to all attendees. If there's anyone else you'd like me to send it out to, please let me know. And that's all for myself. If you'd like to get in touch, my email is luke.newcomb@enterprise-ireland.com. And that's all for myself. So thank you very much and have a great afternoon, everyone.
Thank you.
Thank you.
Thank
Thanks,
you.
everyone. Bye.